Hello and welcome to the Modern Divorce Navigator live series. I'm your host, Billy Tarasio, Arizona family law attorney, owner of the Modern Divorce Navigator and Modern Law. So, on the Navigator Lives, we are open to our members who can come on and ask whatever questions you'd like about your family law case. And we'll brainstorm on that case. We'll talk about different ideas, different things you might want to think about. But it's important before we get started for you to know a few things. I don't become your lawyer, even though I am a lawyer, even though we're talking about your case. This is not the same thing as having a lawyer who represents you, who you hire to represent you in court. And any information that I'm giving you is based on the limited information that you give me. So it's really important that you keep that in mind. Use the information at your own risk and at your own knowledge of your case, and understand that there's no client confidentiality, no attorney-client privilege, and you do not become a client or have any of those rights by being part of the Navigator. But with that being said, I will let everybody in and we will do Q&A. Hello, Julie. Hello, Nicole. How are you all today?
Hi, Billy. Sorry.
Hi, Julie. How are you?
Good, thank you. How are you?
Doing great. How can I help you today?
Oh, I just joined. Sorry, let me get situated here. Um,
Welcome.
Thank you. I appreciate it. I'm trying to be diligently working on my education. I downloaded the planner and I'm just getting started. I have a question in regards to finances. I I'm starting to save money for legal costs and for other expenses. I have a CD that I opened recently, and I also have my own savings account. Should I keep them open or should I liquidate everything now?
So you have not filed for divorce? No one has filed for divorce?
No, not yet. We
Okay.
didn't. We didn't discuss it, but we both know it's coming.
Okay. And where do you live?
I'm in Gilbert.
You're in Gilbert. Okay. So, Gilbert, Arizona is a community property state. That means everything that either of you own as of the date that you file for that divorce and you serve that petition will be subject to division. So, whether it's in the form of cash or a CD doesn't really matter. Now, if you have to spend that for something, if you're thinking about liquidating your CD because you need the money to spend it on something like attorney's fees or something else, then you absolutely can do that before you file for divorce, but not afterwards.
Okay. So, do I have to spend it down?
Do you
So
have to
if I,
spend it down?
it's not like filing for bankruptcy where you actually have to spend down everything, right?
You do not need to spend down.
Okay. All right. Understood. Understood.
All right?
And the division, is that a negotiable
Yes.
process?
Yes.
Okay.
Yes.
Great. Okay.
Everything
Great.
in divorce, you will have the ability to negotiate.
Okay.
And just because we live in a community property state where everything is community property doesn't mean that you don't have the ability to work together to figure out something that will work for both of you.
Understood. All right. Appreciate it. Thank you.
Absolutely. And we'll come back to you if we have time at the end.
All right. Thank you.
Nicole, how can I help you? Okay. Nicole, I cannot hear you. So I'm going to go over to Julie. Julie, how can I help you today?
You just answered my question. I appreciate it. Thank you.
Yes. Oh, sorry. Lisa.
No worries.
Lisa, how can I help you today?
Hi, hi, Billy. How are you?
I'm doing great. How are you?
Good, thank you. I have a few questions, but maybe I could just start with one. So when I am self-represented litigant and I'm going to court, I'm having a hard time speaking up with the judge because my ex, my daughter's father has an attorney, and then there's a GAL who's also usually on Zoom when we're in a hearing. And I feel like I'm not being heard at all. Like I'll try to, the last hearing, she didn't even talk to me whatsoever. She asked the GAL if he had any updates. She asked, and my ex's attorney was speaking, and I just didn't get a word in edgewise, and I don't know what to do. I don't, maybe I feel a little intimidated when I'm in court. I have, by the way, read and listened to all the trial skills that you'd recommended on your online portal. So I'm not sure if I should just, I guess I should just kind of speak up, but I feel like so intimidated because sometimes the judge will just shut me down. And then I feel like, oh, am I doing a disservice? I can't even finish my sentence. So
Right.
maybe I'm not presenting myself well enough, but
Are
it's
these
just really hard to balance it out. I just don't know what to do. If you have any
well,
advice.
yes, you are in a difficult position. Now, I'm assuming that these are non-evidentiary hearings. They're like status conferences and RMCs. Is that right?
Correct. Yes. Yes.
Yeah. So because those are rather informal, um, this is where the biggest risk is if you're representing yourself to just feel like you're getting railroaded. So what's important is that you go into each of those status conferences or RMCs knowing exactly what it is you want to get out of that status conference or that RMC. So do you mind sharing kind of an example of, because it's not about the minutes that you've spoken to the judge. That's not what we really care about. What we really care about is what is the outcome of this status or RMC. So what's been happening at those?
So we had our last hearing last week, and the judge wanted an update from the GAL. That was sort of the last thing. The majority of the time, my ex-husband's lawyer spoke. So my daughter is currently seeing a therapist at the recommendation of the GAL. He updated her and said, yes, she has been going, and there's no signs at the moment of self-harm, because that's the reason why I was able to get an emergency suspension of his parenting time, because she's 12. She no longer wants to go to her dad's and has been to the point where she has these extreme panic attacks. And in January, she threatened that she would run away and kill herself if she was being forced to go to her dad's. So I had no choice but to file that with the judge, with the courts. So since then, she has been seeing a psychiatrist every week. But she has not been reported to self-harm since that incident in January, because she's with me now and she's not being forced to go to her dad's. The GAL had recommended to the court 2 months ago at a hearing that Tony is his name, so that her dad should see my daughter twice a week when it was convenient and it worked with her schedule. So she currently gets picked up by him after school and on Thursdays until 6:00, and then also on Sundays she sees him from after church till 6:00 as well. So she comes back with anxiety. She throws up. She's exhibiting still a lot of like extreme stress when she spends time with him, but she's no longer, threatening because she's not being forced to go there overnights. It's more like staying overnight, and it's more about being with him for a long period of time that she has trouble with. And just as a background, there's been a lot of coercive control, which is something I've recently discovered a word, because I couldn't figure out what it was. I was like, is he a narcissist? Because there was no like physical, like outright abuse. There have been incidences where I've been, pushed and knocked down to the floor, but I think it's only been like since 2019 that I left the house that I'm finally realizing what was happening. It was like all this coercive control and gaslighting and manipulation. And I think this is what's happening with my daughter. Anyway, long story short, she's still exhibiting signs of high anxiety. She's still seeing the therapist, although I don't know if the therapist is really doing much at this point in terms of helping her with her anxiety. It's almost like she's just it's talk therapy mostly.
Okay. So, Lisa, is that what you wish you would have told the judge? Like, because my question was, what did you want to get out of the status conference?
Correct. Yes. Okay. So my problem is that my ex-husband, he filed a order to vacate, like a petition to vacate the emergency order for suspension of his parenting time. It was temporary. The judge, we are hearing this at the end of the month. There's going to be a hearing for it. But he also subsequently filed a motion to amend parenting time and parenting responsibilities. So he wanted to take all parenting responsibility away from me. And he wanted the majority of parenting time, saying his allegation was that I was poisoning and alienating my child from him.
Okay, Lisa, this is why you representing yourself in court against a lawyer. This is why you're getting railroaded because I asked like a very specific question, and I understand that you think it's really important for me to have all this background, but
Yeah.
but I'm essentially acting kind of in the same position a judge is right now because I have all these people waiting for me, and um, they judges need you to be much more clear and concise. So if my question to you is what do you get out of the status conference, what did you want to get out of the status conference, possible answers from you could be things like I want the current order to continue, or I want a modification to the current order, or I need a evidentiary hearing to be set, or I'm looking for the judge to give me certain documents on a motion to compel. So everything that you're talking about would have no relevance to the status conference.
Got it. Is there somewhere I can learn about these, what to ask a judge in terms of
Yeah.
representing myself and moving forward my petitions? I
I
have a
think
petition out there, but I feel like, yeah. And the other thing is that the attorney, my ex-husband's attorney, she's writing up the court orders, and they're not necessarily pertaining to what the judge ordered. So one hearing, she just completely neglected to file the order,
mhm,
and the judge didn't even sanction her, and she was just like,
mhm,
"Oops, I forgot." Like, "Oh, oops, there was
mhm,
so much going on,"
mhm,
and I don't know. I feel like I am being railroaded, and
mhm.
there's just so much. Yeah, so I'm kind of at a loss, but I suppose you're right. Like, I do need to just say specifically what I need
Well,
from the judge.
part of this class, part of the navigator is to teach you about the culture of family court and how it works and how to operate within it, because lawyers know what the judges want and that's what we give them, and then they pay attention to us and they don't pay attention to you. And your question was so good, how do I get the judges to pay attention to me, how do I make sure that my voice is heard? But you have to know, and I want you to keep coming to these lives so we can talk about what's coming up next and what do I need to ask for? What do I need to be prepared to do at this event? Does that make sense?
Yes, thank you so much. I really appreciate it. Yeah,
And
and
I'll
I'll just listen sometimes because I'm new at this, so I'm
yeah,
learning so much. So thank you
you're
so much.
welcome. And if there's time, I'll come back to you, okay?
Okay, thank you.
Andy, how can I help today?
Hi, Billy.
Hi.
So, I just kind of wanted to like bounce this off of you. So, I was supposed to get the autism report yesterday. Was like the 30 days it was supposed to finally be released. And I emailed the office in the morning and I said, "Hey, like there's no court order, or I said, "Hey, today's the day it's supposed to be released." She responded and she said, "Is there any court order or did you guys come to an agreement?" I said, "There's no agreement. There's no court order." I sent her a screenshot of the docket where it showed that he had not retained legal counsel and that he had not filed like a petition or a motion or anything like that. And and I said, you're required to release the report as you initially stated in your communication last month. So she said it'll be uploaded onto the portal by 5 p.m. So I'm like, perfect. At 4 p.m., she calls me and tells me, well, she asked me if I feel like my ex-husband is stable. And I'm like, no, I think he's unhinged. And his I put it in our divorce paperwork that he is required to get a psychological evaluation and that he should be doing, therapy for anger management and impulse control. And I don't think he's followed through on any of that. And she's like, okay, well, I feel that he's very unstable. He's threatening me. I don't feel safe releasing the report. So now I'm not releasing the report.
Why doesn't she
Um,
just tell it to you?
Yeah, I don't understand. I'm so confused. And so she's like, I'm not releasing it. And she wouldn't tell me what he's threatening. She wouldn't say like he said this or that or whatever. So I'm like, okay, so I immediately get in contact with my lawyer and I'm like, I don't know what to do. And I'm like freaked out because he works in healthcare, so he knows what the like legal implications are of like threatening a healthcare provider. Um and so then she's like, we're going to draft the, emergency order for temporary orders or whatever it is to get
Who's
the
that?
sole decision making. My attorney. So
That's not
she
your
said,
fault.
yeah, so that's what I'm like, I'm not sure what to do in this situation. And so that was like what her insight was essentially we need to file the emergency petition for temporary orders for the sole decision making so that I can
Yeah.
get that or something. And
And
then,
solves your problem because your problem right now is getting this healthcare provider to give you the records. That's your problem. And so, it'd be great if your lawyer could reach out to the lawyer for the medical practice,
yeah,
right?
well, so I asked her that and she was like, no, because the doctor was like, can you call me back in the morning? Once you can speak with your attorney. And I was like, okay. Because she was basically begging me, like, please don't make me release this report. Like, I don't want to release it.
Why
Like I will, she's like,
can't
I'll pay back your insurance and I'll give you back your copay. But I don't want to release the report. And she's saying that it's not good for any of us. And she said that because I admitted to signing his name on the intake form that it's not going to be good for me either, and that judges and family court aren't going to see that um, as a favorable move. Like it's going to work against me, and that it's going to have negative effects on me.
Okay, well, that's not her call. You get to decide how you want to use the report.
Well, that's what I said. I was like, I'm not concerned about me.
I would just tell her that you want her to email it to you. And you understand that you have concerns about him, that she has concerns about him, and you're not going to provide it to him, but you would like the report.
I tried that. She won't release it.
Okay. Well, then you're going to have to move on and get a new evaluation.
But I can't do that without the sole decision making.
Why
I
not?
can't find
You have final say.
I know, but none of these places will do an evaluation on him without both parents' consent. I don't understand.
Then,
It's the same thing I'm running into with trying to get my 6-year-old therapy. Like, no therapy office will see him without both parents' consent.
okay, well, that's a good reason to get sole legal decision making. If you can get in writing from several providers, I will not perform services unless you have sole legal decision making. That's a decent reason for a court to give you sole decision making because right now you have the ability to access all of these services. So it is the policies of the doctors that are preventing you, not your family law status.
Yeah, okay, that's what I thought. But even the doctor is like telling me it's different with mental health. And I'm like, well, it doesn't say that in my court paperwork. I'm like, it's like a gray area.
Nope. It's just their policy. So it's just their policy. And they are deciding that they're not going to give you services. And it is their right to refuse you services.
Okay, that's what I thought. She's like convincing me that like the attorneys I've spoken to, like you and my attorney have said the same thing. And I'm like, it seems like a gray area. She's like, no, it's very black and white. And I'm like, well, then I should get the report.
Mm-hmm.
Okay. So then I can reach out to I guess I'll just reach out then.
I think
Um,
if you want emails from different doctors telling you, no, we won't help you.
Well, and she also confirmed that the threats are via email from my ex, and she won't tell me what he said. She won't provide them.
Oh, subpoena them.
Just tell my attorney to
Yeah,
subpoena the.
them. Because
Okay.
that's not protected healthcare information. She can't hide behind HIPAA. If she's getting,
That's what I
do
thought.
you know what I mean? Like that's not healthcare information. It's threats
I'm
via email.
Yeah, I'm like, how can you not release this information to me? Because she hasn't told me any of like this whole time any of his concerns or like any of the communications that he's had with her. She's like, I can just discuss like your side of it, basically. Like I can't discuss the communications with him. And I'm like, why not?
Yeah.
Okay. Well then
Man,
I will.
I'm sorry. Like you are in a mess.
Oh, it's a shit show nightmare. Yeah. And I'm like, I didn't sleep last night because I'm like scared for my safety because I'm like, if he's willing to threaten a healthcare provider over releasing a diagnostic report, I'm like, for me, I'm like, he's spiraling. Like he's losing power and control and he's spiraling.
Yeah. All right. Thank you, Andy. We'll come back to you,
Thank you.
okay?
Okay, thanks.
Kevin, how can I help today?
Billy, thank you so much for this. I appreciate it. I just finished the Navigator course on trials and it was extremely helpful. So thank you, thank you, thank you. There are no comments, so I can't leave a comment on YouTube, but thank you.
I appreciate
The
that feedback. It's really an important thing, so I appreciate it, Kevin.
Absolutely. The reason for my question is multifaceted. I just found out that my plaintiff or petitioner, ex-wife, she did the affidavit. Our trial is on Wednesday, but she did not complete the affidavit. I submitted a ARS statute, but I unfortunately used the CA one instead of the FLA one. So I got a letter back today from the judge saying your request for sanctions is denied because it's the wrong ARS that you quoted, and she only had to do 40 questions. If we add up all the questions and the sub questions, there's 40 questions right there. So is there any other way that I can ask for sanctions when I get into the courtroom on Wednesday?
Okay, so you're asking for sanctions against the opposing party or the opposing attorney?
The opposing party.
Okay, and based on what? What did they do that broke the rules?
I just found out today that for the last 7 months, she has been operating a company. She's listed it as a nonprofit, but she does collect money, and she is being offered a grant. She never listed any of this information in any of her financial affidavits, but her attorney, not the current one she has now, the last one, claimed that I was withholding information on my financial records for my business, although that is not true.
Okay, so I think it's Arizona Rules of Family Law Procedure 65C, maybe. Failure to make disclosures in court. Rule 65, Arizona Rules of Family Law Procedure. Go look at that rule,
Okay.
and that yep, B is sanctions. Okay.
Absolutely. Thank you. My next
You're
question is when I get into the courtroom, I have a new piece of evidence. I finished Case Center the day before yesterday, and I also sent an e folder to the opposing party's counsel because we agreed mutually that we will share digital folders. My folder includes audio and video, which is why digital folder was so important. So I'm grateful that they accepted it. But now that I have this new information about her operating this nonprofit and not disclosing it, I have more evidence to submit. So I submitted it to Case Center. I added it to the e folder. Do I need to make a blank motion and let the judge know, hey, I got a new piece of evidence that
no,
wasn't in the original pretrial statement?
no,
Okay.
no.
Okay. I just bring it up the day of court
Yes.
and I
Or
say I would like to admit this. I know.
you could file an amended pretrial based on newly discovered evidence. That would be fine. Or you can just bring it up at trial.
Okay. I am a little shell shocked when it comes on the trial. In 2023, I had a trial for the same issues. I did horrible, Billy. I got off. This was before Case Center, so none of my evidence was admitted because I misnumbered it. I did so bad. But now that we have Case Center, I'm praying to God that it's a lot easier, like they claim it to be. Um, but you guys mentioned in the Navigator that there's still a chance that things are going to be renumbered. Is that no longer true now that Case Center is handling all the exhibits?
Oh, that's a great question. Let me ask my attorneys in Slack, and I'll let you know what they say when I get an answer, okay?
Thank you so much.
Yeah. All right, and I'll come back to you and I'll let you know what that is. All right, so hold on 1 minute while I type this up. Okay. Okay. All right, Kevin, I'll come back to you with that answer, and let's go over to Hillary.
Sorry about that. I did my video and not my audio. um, so last week you did your deposition training, right? I am pro se right now. I had an attorney, but they essentially, this has been going on 2 years and I got run out of money. So
Yeah.
there is,
happens.
yeah, and it's, I won't even get into it, how complicated it is. I have a deposition coming up next week where I am being deposed, and I will just say that I've got 3 attorneys on the other side and all 3 are out for blood. And so I won't be protected by an attorney, right? And I don't know how to say object for myself to preserve those for appeal or whatnot. Like what would you do as a pro se on your own in a deposition?
Well, you can just say objection, calls for speculation, and then answer the question. That
Is
way,
there-
so let's say objection calls for speculation, and then you go ahead and answer the question. If they tried to use that piece of your deposition at trial, you could say there's a pending objection for you to rule on, and then the court would either let that in from the deposition or not.
Would it be important to object as often as possible, or is that okay?
Are you in Arizona?
No, I'm not.
Oh, then maybe. Where are you?
The case is in Oregon.
The case is in Oregon. Okay, so Oregon does follow the rules of evidence. Okay, so that means if it is hearsay, Oregon will keep it out. So yes, I do want you to object.
Is there an online resource that you can think of that would have the standard, I don't want to say standard, but objections for me to
Yes, we have
look
a
at?
handout. We have a handout. It should be on the Navigator and in the Navigator Facebook group.
Fantastic.
I take it with me to trial every time I go. I just want them in front of me. Even though I know what they are, even though I probably don't need the handout, like I want all of the common objections in front of me because, there's a lot going on in trial or deposition. So I think you should use the tool.
Okay, great. Thank you.
Yep. And then Kevin, I got an answer back, and no, the exhibit will not be changed. So it's now petitioner's exhibits and respondent's exhibits, and there's no more changing. Yay! That's a great thing.
Yeah, thank you.
You're welcome. Kayla, you have any questions today?
Hi, is it me?
Yes.
Okay. I have a question. My sister, she's never been married, and I've been trying to navigate the Navigator process in order to see if any of it is valid for her. She has 2 children. They're 5 and 7. She's never taken him to court for paternity or child support. He gets paid everything under the table, but he has a house in Arizona, and he's about to buy a house in Illinois. I have no idea how, but he has a lot of money. And so we're trying to figure out, like, through this process, we don't have a lot of money. Is it going to bury us to even pursue him for child support? If it's going to even be worth it if we can't hire a lawyer?
So one of the things that I like to do in this circumstance is subpoena or request in discovery the loan application, but I really want to get it from the bank because nobody ever writes down less income on their loan application because they're trying to qualify. So I would use that to prove his income.
My concern is that it would be under his dad's name. I know his house in Arizona is in his dad's name, and so I'm wondering if the other one is going to be in his dad's name. And then the other thing is they have been practicing 50-50 custody since the kids were born, and so he's had him half the week, but his name isn't on the birth certificate. And so what I'm worried about is because the paternity has to be established before you can subpoena to look at any financial records. Do you know what I mean?
Yes, definitely. Yeah. Yeah. So you would need to open a case in order to get the ability to do any subpoenas. So you would have to file a petition for paternity, legal decision making, parenting time, and child support. And then under that, if he wanted to object to paternity, then you would deal with that first. But let's say he doesn't object to paternity, then you can go ahead and subpoena.
Okay, thank you.
You're welcome. Let's see. Does anybody have any questions I have not gotten to yet?
I had one, Billy. I put it in the chat, but I wasn't sure if you saw it.
I didn't. Do you want to just ask me?
Yeah, that's fine. So yesterday was the cutoff for our notices and motions to be filed for a trial in 2 weeks. And the opposing party's fiance sent over at 9:00 last night the half completed responses to my request for admission. He perjured himself in it, which is perfect. Again, and I filed a motion to deem them the request admitted. It was after the cutoff for the court because, of course, it was sent so late. I'm hoping it will get in. However, what other options do I have as far as getting that in?
Okay, so you sent a request for admissions.
Yes.
And did they respond in time or no?
Yes, they responded in time, incomplete, and did not include all the requests.
Okay, so anything they didn't answer should be deemed admitted.
Perfect.
In terms of whether it's incomplete, I mean, I would want to look specifically at the rule. Does the rule say anything not answered completely is deemed admitted?
I would have to pull up the rule exactly, but I literally copied it straight from the rule.
Yeah.
But even like within his answers, he wrote, "See attached documentation." There's no attachment. But this is par for the course.
Yeah. So that would be, I think, an admission. That's
Okay. But I mean, yes, I knew the answers going into it. I just wanted to put it on record. So
you filed what did you file?
A motion to deem request admitted.
Okay. All right. And now you just got to wait and see what happens?
Yeah, we'll see if he gets out of prison in time. I don't know. We'll see what happens.
Man.
It's a fun game, I guess. Like, we'll just see what happens. It's always something.
You're the winner of the game in this particular trial, so.
And I'm not worried about that. I just want to do right by my child. And if that means playing these stupid games for a few more weeks, I've survived 16 months. I can go a couple more weeks.
Good for you, Nicole. Way to hang in there.
Thank you.
Anybody else, feel free to jump in. Lisa, should we go back to talking about your case?
Hi, yes, please. Yeah, so at the next hearing, we're going to be listening to the emergency, we'll be hearing the emergency motion to reconsider and vacate the order. The judge didn't feel it was an emergency, and it was filed back in February 6th. So we'll only be hearing that now at the end of this month. And then in the hearing, we are supposed to be also getting a status. The other attorney had written in the court order, and I don't have it in front of me right now, but it's just I mean, obviously I think she was just trying to make it so that it was like it looked favorable for her client. But I have like rule to show cause for his violation of the mutual no contact order. Like there's been over 20 instances plus other other incidences that he's done, violations of the mutual order, because, as you know, I had filed a order of protection, but because we couldn't subpoena the police, they said that, the police report was just hearsay. So the policemen that were here during the SWAT incident, we couldn't get any of them to come because they were all, Chicago, I guess, and everybody was like, 2 of them were in bereavement. Anyway, I don't know how. Do I do a motion to compel if I don't get a specific hearing date at the next? So at the next hearing, we're going to be hearing the motion to vacate, but then I've got all these other, so that was February 6th. So does the court go in order? And sometimes I feel like, I've been in court for so long, I feel like sometimes motions get missed and it takes like a year here in Chicago.
Yeah.
And so I just want to make sure that we're I'm on top of things and things are progressing, and it doesn't get lost.
Yeah, you can file, here we file something called a request for ruling when that happens, or a notice of deadline. Those are 2 things that I have filed in that specific situation where you have motions pending that simply aren't being answered.
Is that the same as a motion to compel?
No, a motion to compel is a motion to get evidence, to compel someone to give you evidence and discovery.
Okay. What was the names of the? I'll see if there's something similar here in Illinois. What are the names of the motions?
A request for ruling.
Request for ruling. Okay.
And one time we couldn't get it, and we went to the presiding judge, and we're like, this guy won't answer our questions. And the presiding judge told us to file a notice of deadlines. So we did that, and we got a ruling. Probably because we tattled to the boss of the judge.
Okay. Good to know. Okay. And then in those situations, like here in Illinois, there's you get 28 days, sometimes 21 to respond, and then 14 days to reply. So of a petition or motion, would that apply? Would the other side say, well, we haven't responded, so we need to go back and do 28 days? Or are they?
Judges don't rule on motions until all of those deadlines have run and everybody's been given the opportunity to respond.
Okay, but it must be stated in a court order, correct?
No, usually the rules tell you how long you have to respond to motions and how long you have to reply.
Okay, because poisoning my child's parental alienation, he wants full custody. I replied to that petition, and that was February 26th, but they seem to have just completely left that out of the court order. They meaning my ex's attorney, and she was the one that filed that motion. So what do I do in that case? Do I ask the judge at the next hearing to to give them 28 days 14 days to reply to my response?
No, they already had their 14 days. There's no reply, right?
Gone. Oh, good. Okay. So maybe they just decided to drop that. Was that why there's nothing, crickets on that side about this particular motion?
Yeah. So they filed a motion. You filed a response. They did not file a reply.
Correct. Yes.
Now you're just waiting for the judge to rule.
Oh, okay. So then I need to file something. It's called request for ruling, right? Or notice of deadline if she doesn't respond to me verbally at the next hearing. Is that right?
I don't know if that's what you're supposed to file.
Oh, okay.
You'll want to look in your rules to see if there's something like that. But honestly, you guys, a motion is just really anything you ask the court to do. So you can kind of file a motion for almost anything. Although you want it to be specific enough and sound legal enough so that it feels legit. You don't want to file a motion to order the other parent to conduct their phone calls at the time the court ordered. You don't want to do that. But you can file things like a motion for intervention regarding X or Y. You know what I mean? Because a motion is just a request.
Okay. Do you feel like it's important for the court to, I mean, I don't know what the word is, I guess, to memorialize the fact? I feel like it's just was a motion thrown out there, seemingly like without cause or it was baseless.
If
And
you
I,
don't want, if you don't benefit from a ruling on this, like if it's done and it's lying and there's no problem, then don't poke the bear.
oh, really? Really? Okay. Because he always does this. Like I filed for my order of protection at the advice of the SWAT sergeant for this felony offense, knowing that, you know, what he did, he knew that I had my parenting time with her and he did it on purpose to harm me. I mean, people get killed in Chicago every day from these, you know, swatting incidences and raids in my home. And so when I filed that order of protection, he came back with a counter filing that I was concealing his child during his parenting time. So then that got lost, right? So like I feel like he keeps doing these things and then they get lost and they don't get like put into the orders, the judge's order, like saying, you know. So but you're saying just leave it, like if it's just out there, it's
It's not
filed.
hurting you. If there's nothing that you want or you need the court to do, then that is not where I would put my efforts.
Okay. So just leave that be.
Yes.
Okay. Because we
Do we have any other questions? Ashley, do you have any questions?
I do, and I apologize. I wanted to log on at the beginning, and I just started to be a member of the Navigator.
Oh, welcome.
Very useful. Thank you guys so much. I am trying to possibly get representation from one of you guys. I did go to a law day back in the day, and yeah, hopefully I can afford it. But in the meantime, I had to finally make a claim with DCS on a couple, actually at least 6 different occasions where I was concerned. And since I've been using community legal services as well, they are recommending I do my modification for parenting time, child support, and legal decision making. Now, the most important question I really need answered today is, while I'm doing that, I'm at the domestic violence category. Now, so far, I've never been physically assaulted by this man, but definitely sexually, and as well as me and the kids, emotionally and mentally. I have proof on all that, but when it comes to the domestic violence, it hasn't yet been reported to the court. I do have a final order, obviously, in which he has sole custody, and I'm trying to change that as soon as possible. So I'm not sure what to include under domestic violence. Like, it has occurred, but like, I don't want to open a bag of worms, and I don't know exactly what to put.
So you're getting representation through community legal services, and they took your case because you have experienced domestic violence, and now you're getting ready to file, and you're wondering whether or not you should allege the domestic violence?
Well, no, they didn't appoint me it because of domestic violence. I have community legal services because of my income.
Okay.
So
is this a divorce or a modification?
This is a modification in which the order was already, it's been, I think 2023 is when this order was put into place. So I had a relapse in substances. I was in recovery already after 3 months. I had 10 years before that. My kids never experienced me on drugs. But I had a relapse after a bunch of trying to get away from this man. And because of that, he used that to get sole custody and he was fine with it. Like, he knew I was getting off in my treatment program, but I had to file an order of protection and call the cops because he tried to physically rape me. And once I filed the order of protection to where he wasn't allowed to contact me, that's when he filed emergency orders to get my kids with a bunch of false allegations. He just exaggerated my relapse times like 1,000. And so
you're wondering if you should tell the family court about the attempted rape and the order of protection? Yes, you should.
Okay, So that right there, I didn't like. I have so much, and it's so complex, Billy. I'm sorry. It's so hard for me to keep all of the stuff organized, and I've had so much done to me that it's hard for me to remember what came first, chicken or the egg. So you just answered my question right there.
Oh, good.
I will just put that, and because that has actual police reports. If I could real quick, right after that, I'm going to file for the temporary orders to get at least some parenting time, or at least family therapy started. Once I file that, how long does it usually take for them to, get us into court?
So he has an emergency ex parte order for sole custody. Is that correct?
Yes. I think it's just a regular order now because it's been on for 3 years. Like we went.
For
Yeah.
3 years, he's had sole custody, and you have not had any parenting time?
I was allotted 2 to 4 hours a day for 2 days out of the week, supervised through a facility in which it cost me at least $60 an hour. And at this point has caused more trauma than good. It's feeding the kids the stigma that mom is unsafe. You can't be alone with her. Anyway, and then on top of that, I get phone calls, which I try and schedule on a regular basis, never works, but he is to supervise my phone calls. He does not supervise. He interacts, interferes, and actually, pretty much directs.
Okay. So you want to go back and get a modification and get unsupervised parenting time with your kids. Is that the goal?
Yes.
And the reason that it's supervised is because of an alcohol or drug relapse?
A drug relapse. Okay. I have proof
before you file your modification, I want you to have clean testing. And then you file your modification, you tell the court circumstances have changed, you're no longer an addict, you have stable housing, you have a job, and you want regular parenting time. And it should be fairly straightforward because parents who are safe, who are clean, who have housing, who have jobs, shouldn't be on supervised parenting time. This shouldn't have lasted for 3 years. So if you are not a danger to your children, then you need to get in there as soon as you can and get this order fixed.
Absolutely. I actually had to do some DCS reports. I actually was I had another child. I have a 10-month-old. I got clean when I had him, and DCS was involved. They dismissed the case because there was nothing. It was just the first time at the beginning when I had him. So I've already gone through all the ringers, and I have proof of 7 months clean UAs, as well as at least 5 certificates of completion of treatment. And actually, I got my peer support certification, and doing really good. I blame myself for the lengthiness of the time just because I'm scared of him, and I was scared of him. And I didn't really know what to do after being told over and over again I was incapable of taking care of myself, let alone my kids. I really second-guessed myself, and I've been getting a lot of treatment for that, and the kids are suffering immensely. So I will do that, but with the timeline, so if I file those today, say they would probably get back to me in couple weeks for temporary emergency, or not emergency, but temporary orders?
It depends on your judge.
Okay.
Let me ask. I am not sure right now how long it is taking for people to get temporary orders, but it could be a couple months.
Okay. That's what I was just trying to get, a ballpark. I'm really just trying to get, my son has had suicidal attempts, and there's a lot going on. Honestly, Billy, I'll probably try and get in and get Ruby assigned to my case. That's who I worked with on the law day, as well as I've been in contact. We're actually friends now, the FAST team. I'm not sure if you're familiar with them. It's a group of lawyers, or actually a lawyer and a social worker, Kristen Foster and Jennifer Harrison. That Ruby, I think, used to work at the same place actually with them, and they referred me to try and get her as my representation.
She's great. She's absolutely great.
So I don't want to take up a bunch of time on this Q&A because there's a lot to go with it, but I just wanted to ask that those. I might have some down the road if I can't get her on board right away.
Thank you, Ashley.
I appreciate your time. Thank you.
Any other questions in our last few minutes today?
If no one else has any questions, can I just kind of confirm with you that you think, in your opinion, that filing for sole decision making, like for the temporary orders, is like the best way to go for that situation?
If you can get at least several doctor's offices in writing to tell you they will not give you treatment unless you have sole legal decision making. But I
Okay.
wouldn't do it before then.
Okay.
And
Well, that's
again,
good
this
to
is
know.
a judgment call, right? This is a judgment call. So, you know, that's the danger of talking to more than one attorney is like, ultimately, this is your decision no matter what lawyer you work with, but it is a judgment call.
Okay. Well, that's what I feel like too, is like I'm in the driver's seat, but that's why it's like helpful to have the input.
Yeah,
Okay,
absolutely.
thanks, Billy.
You're welcome. Nadia, how can we help today?
Oh, I'm just new and I wasn't sure if I would be able to get in. I've tried a couple of times and it was canceled, or I didn't know it was canceled or something. So I'm just new to representing myself, and I did file my first e-file my first document a few days ago, and I'm process for checking to see if I did everything correctly. Can I call the court, or is there like a phone number, a place that I can call and see if anything was missing? And then how long does it usually take for the judge to respond to a motion?
Okay, so no, you can't call the court and be like, "Did I do this right?" They won't tell you. So, and then how long does it take to respond? Excuse me.
Yeah.
It definitely depends on the judge. Excuse me. But also, you have to give the other side a chance to respond, which is a 10-day deadline. And then you get another 5 days before to reply. So it doesn't happen right away.
Oh, okay. Okay, that's good to know. I also joined the Facebook group, and I'm not exactly sure where to post questions, general questions. There were a couple of different categories, and I posted something, I think, yesterday, and I wasn't sure,
I'm in the same boat.
how to go about.
So you posted something yesterday but didn't get a response?
Well, on the group, like you go into the group and there's like 4 categories. There's not like a general Q&A kind of thing. Sorry,
Really?
I don't mean to interrupt. I hope that helps.
You can't just write something, because like when I'm in there right now and it's, you can, oh, here, I'll share my screen. No, I can't share my screen. Can I share my screen? Yes, I can. All right, let me share my screen.
Can I go through right here?
So I can just create a post right here and write whatever you want. So you can't do that?
It didn't look like that when I went in. Let me try again.
Okay.
It had like 4 categories. I'll try to get a screenshot for you.
Yeah, definitely. Definitely. Okay, so and did you post your motion in there?
No, I didn't.
Okay.
I'm super new.
Okay. Well, if you want to, we can take a look at it.
Okay, great. I actually didn't write it myself. I was with your law firm and ran out of money. So I'm doing pro se now, and I didn't even know about this navigator thing. I just sort of stumbled upon it through YouTube. I was searching
Wow.
how to represent yourself on YouTube, and I found one of your shorts, and then I went, and I didn't even know it was you. And then I went and found the website
Mm.
and thought, oh, this looks awesome. I can maybe, get some Q&A and stuff like that. So I'm just trying to learn how, the ins and outs of how to do it.
Yeah. Well, we're glad that you're here, Nadia. We
My
have
motion.
office hours every
Yeah.
single week, and then definitely post your questions and your documents and whatever you need help with in the Facebook group. Simo, I see that you've joined. We have just a few minutes. How can I help today? Are you there, Simo?
Hello, can you hear me?
Yes, I can. How can I help?
Hang on a second. I have a camera too. Let me see if I can make that. Okay. Hi.
Hello, welcome.
Yes. Hey, am I in the right place? I'm not sure. I think I missed the first meeting you guys had. I just joined maybe a month ago or something, but I'm so overwhelmed that I didn't get to participate at all. You're helping with divorce questions, right?
Yep, this is a live Q&A. We do this every single week as for members of the Modern Divorce Navigator. It's 1 hour, so we started at 1 o'clock Arizona time, and I'll answer whatever questions you have to the best of my ability.
Okay, so I'm on the eastern side, so maybe that's why I'm catching off time. So, divorce. It's like 2.5 years ordeal so far. And my ex is on his third lawyer. I have had multiple challenges, and we had a trial date. We have a receiver on the case, an accountant, because of marital assets being wasted and all that. And I got a bit frustrated with my own lawyer, thinking that, maybe there is something there, but I'm okay. There were some misunderstandings. I don't even know where to start.
Well, we only have a couple minutes because our hour's almost up. So
Yeah.
do you have any specific burning questions I can answer today?
No, and I wasn't prepared, and I apologize.
Sure.
I joined late.
No
I gotta
problem.
think. It's really, it's just about division of assets, where I'm struggling with, and the fact that right now something really unusual was requested to a bifurcation, which is like
Yeah.
he wants to get divorced and then
Mm-hmm.
separation of assets being later.
Mm-hmm.
But I don't know if that's something that is this even like a possibility, or like
Mm-hmm. That's a great question. So it
accepted like a
depends.
Go ahead.
It depends on the state. So in California, for instance, people bifurcate their divorces a lot. That means they'll get legally divorced. So they'll be retained to the status of a single person even while the other things are still happening, like their child custody things are still happening, or their property division things are still happening. In Arizona, we don't do that. We don't offer a divorce before all of those issues are done, but we sometimes bifurcate a case so that you might deal with the child custody issues first and then the property issues later. I personally think bifurcating issues is a great idea because it gets people focused and specific. And the judge doesn't have to get confused. And like it, in my experience, anytime you can make something more specific and clearer, you get better outcomes from judges. So I'm generally speaking, I don't know your case, but generally speaking, I'm not opposed to bifurcation.
Okay. Well, my case is in Oklahoma,
Mm-hmm.
and the problem is that we do have a trust that it's on his name, and he's trying that's invested in real estate properties,
Mm-hmm.
and by divorce he's going to probably start selling. If he already did one of the properties, and against receiving orders, violations right and left. So it's a matter of him dissipating assets, not necessarily a meaningful, you know, we don't have custody, we don't have alimony in place, it's just separation of assets. And now we got to the point where we have to put liens on the properties so they don't get sold like without notice. It's a nightmare. But anyways, I will get more specific with questions next time.
All right.
So
I'll
for
see you next week.
Okay,
Thank you
thank you
everyone
so
for
much.
coming. We'll see you all next week. Bye.
Bye bye.